Good day, ma'am. Here's our video presentation about Republic Act number 9165, also known as Comprehensive Dangerous Drug Act of 2002. Salient features of RE 9165. The Comprehensive Dangerous Drug Act of 2002 made significant changes in RE 6425 as amended by RE 7659 on the classification of the drugs into dangerous drugs and controlled precursors and essential chemicals, the basic nature and gravity of the penalty, limited supplementary effect of the RPC, the addition of new offenses and new offender like the financier and protector, cuddler, the effect of the commission of the crime while under the influence of drugs, the provision of treatment, and the rehabilitation of first-time minor offenders, among others. The rationale of RE 9165. It is a policy of the state to safeguard the integrity of its territory and the well-being of its citizenry, particularly the youth, from the harmful effect of dangerous drugs on their physical and mental well-being, and defend the some against act or omission detrimental to their development and preservation. Violation of RE 9165 or Republic Act number 9165 is a malum prohibitum. The RTC, designated as the Special Drugs Court, has jurisdiction over violation of RE 9165. What is the basis of penalty under RE 9165? The penalty is no longer based on the quantity except for possession, but the quantity involved is much lower than the old law, hence harsher use of dangerous drugs has a graduated penalty. The accessory penalties of disqualification to exercise civil and political rights such as the rights of parental authority, guardianship, to dispose of property by any act or convenience inter vivos, the right to vote and be voted for is suspended even during the pendency of appeal from conviction under RE 9165. Unlawful Act and Penalties. Section 4. Importation of dangerous drug and or controlled precursors and essential chemicals. Offenders under penalties. Importer. The penalty of life imprisonment and fine of 500,000 pesos to 10 million fine. Importer. Using diplomatic passport, the penalty of life imprisonment and 10 million fine. Financier, organizer, manager or of importation, the penalty of life imprisonment and 10 million fine. Protector, cuddler, have a 12 years and 1 day to 20 years and fine of 100,000 to 500,000 fine. Section 5. Self-trading, administration, dispensation, delivery, distribution, and transportation of dangerous drugs. The penalty of life imprisonment to death, and have a fine of 500,000 to 10 million. The maximum penalty is imposed on committed within 100 meters from school, use of minors or mentally incapacitated persons as runners, couriers, and messengers, or in any other capacity. If the minor or mentally incapacitated, and next is the dangerous drug, is the proximate cause of death of victim.
Provisions of Section 8 is aware of the nature of the place as such and knowingly visit the same. Penalty, imprisonment 12 years, 1 day to 20 years. 100,000 to 500,000 fine. Aggravating circumstances are any piece of a manufacturing process was conducted in the presence or with the help of minors. Any piece or manufacturing process was established or undertaken within 100 meters of a residential business, church, or school premises. Any clandestine laboratory was secured or protected with booby traps. Any employment or a practitioner, chemical engineer, public official, or foreigner. Section 9. Illegal chemical diversion of controlled precursors and essential chemicals. Penalty 12 years and 1 day to 20 years. 100,000 to 500,000. Section 10. Manufactures or delivery of equipment, instrument, apparatus, and other paraphernalia for dangerous drugs and or controlled precursors and essential chemicals. Penalty. The penalty of 12 years and 1 day to 20 years. 100,000 to 500,000 fine. Section 12. Possession of equipment, instrument, apparatus, and other paraphernalia for dangerous drugs. Penalty: imprisonment of 6 months and 1 day to 4 years. 10,000 to 50,000 fine. Note: the possession of such shall be prima facie evidence that the possessor has smoked, consumed, administered to himself or herself, injected, ingested, or used a dangerous drug and shall be presumed to have violated Section 15 of RA 9165. Section 13. Possession of dangerous drugs during parties, social gatherings, or meetings. Any person found possessing of any dangerous drug during a party or at a social gathering or meeting, or in the proximate company of at least 2 persons, shall suffer the maximum penalties provided for in Section 11 of this Act, regardless of the quantity and purity of such dangerous drugs.
Section 15. Use of dangerous drugs. A person apprehended or arrested who is found to be positive for use of any dangerous drug, after a confirmatory test, shall be imposed a penalty of a minimum of 6 months rehabilitation in a government center for the first offense. If apprehended using any dangerous drug for the second time, he or she shall suffer for the penalty of imprisonment ranging from 6 years and 1 day to 12 years and fine 50,000 to 200,000. Section 16. Cultivation or culture of plants classified as a dangerous drug or a source thereof. Penalty: the penalty of life imprisonment to death, 500,000 to 10 million fine. Section 17. Maintenance and keeping of original records of transactions of dangerous drugs and or controlled precursors and essential chemicals. 18. Unnecessary prescription of dangerous drugs. The penalty of imprisonment from 12 years and 1 day to 20 years. 100,000 to 500,000 fine. Section 19. Unlawful prescription of dangerous drugs. The penalty of life imprisonment to death, 500,000 to 10 million fines. Section 37. Insurance of false or fraudulent drug test results. Section 26. Attempt or conspiracy. Any attempt or conspiracy to commit the following unlawful acts shall be penalized by the same penalty prescribed for the commission of the same. First paragraph, importation. Second, sale or trading, administration, distribution, and transportation. Third, maintenance of a den, dive or resort where any dangerous drug is used in any form. Fourth, manufacture of any dangerous drug and or controlled precursors and essential chemical. And last, cultivation or culture of plants which are sources of dangerous drugs. 7. Public officer or employee is criminally liable for misappropriate, misapplication, or failure to account for the confiscated, seized, and or surrendered dangerous drugs, plants, source of dangerous drugs, controlled precursors, and essential chemicals, instruments, paraphernalia, and or laboratory equipment including the proceeds or properties obtained from the unlawful acts committed. Section 91. Responsibility and liability of law enforcement agencies and other government officials and employees in testing as prosecution witnesses in dangerous drugs cases after due notice, fails or refuses intentionally or negligently to appear as a witnesses for the prosecution in any proceedings involving violations of this act without any valid reason. Penalty: imprisonment of 12 years and 1 day to 20 years plus fine of 500,000 in additional to the administrative liability he or she may be meted out by his or her immediate superior and or appropriate body.
Note: the immediately superior of the government of law enforcement agency or any other government employee mentioned in the preceding paragraph if despite due notice to them and to the witness concerned, the form does not exert reasonable effort to present the latter to the court. Penalty: imprisonment of 2 months and 1 day to years plus 10,000 to 50,000 fine. In additional, perpetual absolute disqualification for public officer. The government of law enforcement agency shall not be transferred or reassigned to any another government office located on another territorial jurisdiction during the pendency of the case. However, the concerned member of the law enforcement agency or government employee may shall be transferred or assigned for compelling reason. In the immediate superior shall notify the court where the case is pending of the order to transfer or reassign within 24 hours from its approval. For delay and bundling in the prosecution of drugs case. Any government officer or employee tasked with the prosecution of drugs related case under this act through
unwarranted laxity, inexcusable neglect, unreasonable delay, all deliberately cause the unsuccessful prosecution and or dismissal of the said drugs case shall suffer the penalty of imprisonment ranging from 12 to 1 year and 1 day to 20. The four lengths that shall be established in
Violation,
the
mga
chain
pamilya
of
ko.
custody. First, the seizure and the making, if practicable, of the illegal drugs recovered from the accused by the apprehending officer. 2. The turnover of the illegal drugs by the apprehending officer to the investigating officer. 3. The turnover by the investigating officer of the illegal drugs to the forensic chemist for laboratory examination. 4. The turnover and submission of the marked illegal drugs from the forensic chemistry for the court. People versus Nandi GR in July 13, 2010. What accused should be taken upon minor drugs violation? Juvenile violation may be given for the first offense. 1. Suspending sentence. Number 2. Probation or community service. 3. Serve of sentence as any another convict person. It says first time minor offender violate any of the rules and regulation of the center of confinement here was required. 6. The condition for the suspending sentence to a minor drugs offender. Suspending sentence shall be given to a minor first-time offender who is over 15 at the commission of the offense of possession but not more than 18 at the time of judgment subject to the following condition. Number 1. He has not been previously conviction of any prevention of any provision of RA 9165 or RA 6425 as amended or the RPC or of any special penal law. He has not committed any crime. Number 2, he has not been previously committed to any center or to acre of the DOH accredited physical physician. 3. The Dangerous Drugs Board probably recommended suspension of this sentence.
That's the end of our video presentation.
Thank you and God bless.